22 states are challenging Trump's executive order, saying any elimination of birthright citizenship is in clear violation of what is guaranteed by the U.S. Constitution. The ACLU of South Carolina, which also opposes the order, further argues any changes to current law could chip away at other rights guaranteed by the 14th Amendment and the Constitution.
The 14th Amendment is also where all citizens get the right to equal protection under the law. And if we don't stand firm on this first attack on this crucial amendment, then other parts of that amendment will fall.
This case will be taken up by the U.S. Supreme Court. The executive order, meanwhile, has not been enforced as it was temporarily blocked by a federal judge in Massachusetts. Alicia?
Andy, thank you for your reporting there. So our chief legal analyst, Kali Froh, is joining us here to be able to talk about this further. You were sitting here, you're listening to Andy Weber's reports. First, let me get your thoughts as to what you just heard.
Well, I have a lot of thoughts, and I don't think we have enough time to cover it.
I mean, let's go through them, Kali. Let's start with the top.
Let's go here. I find it fitting that South Carolina Attorney General, the state that was the last to ratify the 14th Amendment, is now making the argument of how great that it was and how it's being inappropriately used now. I know folks don't like history, but let's go through facts. Let's look at what actually happened. 1868 is when the 14th Amendment was ratified. 30 years later, we can look at case law. Let's look at the Wong case, the preeminent case that looks at the 14th Amendment. And it's not talking about African Americans. It's not talking about black folks. It's talking about an Asian individual that had two Asian parents that were born in this country, then goes to China, attempts to come back to this country, and is denied entrance into this country, even though he's a citizen. What did that court say in a 6-2 opinion? That he's a United States citizen. Not talking about African Americans, not talking about slaves. That case was in 1898, 30 years after this case. So if we want to look at what the folks intended, what the courts intended, what the drafters of this amendment intended, you can only look to this case as every court has looked at over the last 100+ years. If you're looking for precedent, if you're looking for background, if you're looking for content, I think you don't want to look any further in the case that the courts looked at 30 years after they looked at this actual amendment. So I am baffled by the thought that this is something that only addresses African Americans. And the court addressed it in its decision, saying clearly that, yes, we understand that African Americans were the focal point, but they also go through how this is for every citizen that is under the jurisdiction of our country. And so I am lost by his argument, and I hope that our Supreme Court, when looking at this, won't be persuaded by the argument of the day, but will be reminded by precedent, which they are supposed to look at and they're supposed to be guided by when they look at cases like this.
Okay, where can this go at this point? I mean, if you're saying that the Attorney General, which I also want to be able to extend the invitation for him to come on Queen City News, because I think it would be very good to hear in entirety what his argument is, instead of just in a soundbite as to what we just heard there, because we're looking at both sides of this, but specifically what we heard today. If this amendment is misinterpreted, does that open up for the same thing for others?
There's no misinterpretation. Let's be clear again.
Okay.
The courts have clearly spoken. There's never been a time in history when the court has said this has been misinterpreted. This is the argument of the day. In history, the Supreme Court has even said it themselves. Let's not be guided and moved by the argument of the day. Let's be guided by reasoning, by conscience, by logic. Logic would tell you that if you have a case from 1898, 30 years after they implemented this, then by all means, what would have changed that except for the argument of the day that now immigration is something that's bad? And because immigration is something that's bad, you guys are misinterpreted and misreading this. I think that if any law school student is watching this, if anybody that's ever practiced law would listen to that argument, they would say his argument is misguided, because everything in law school teaches you that precedent is what carries the day. So I am, again, lost by the argument, and I would love to watch listen to, I should say, the oral arguments of our Supreme Court look at this case. Because again, for them to have granted cert means that at least 5 want to entertain the argument. So now we have 5 justices that want to talk about it.
Right.
Doesn't mean we have 5 that want to rule against it, but we have 5 that want to at least hear this argument.
So I have to ask you this: can a court make a ruling on what the intent of the law is if it's not clearly stated?
I mean, and that happens all the time. I mean,
Okay.
So
the answer is yes?
Oh, yeah, 100%. That happens all the time. And so when there is a disagreement on the clear reading of it, then you can look at the legislative intent. And typically you look at legislative history. And let's look at this one more time, looking at history. South Carolina only ratified. Why? Not because they wanted to, because they were forced to. At that moment, we had Reconstruction, and Congress said, we're not going to let these states that went against the Union come back to Congress. we're not even going to let you participate in this legislative process until you ratify the 14th Amendment. And what did they say? Once you do that, you can come back. So their hand was forced. It wasn't like they voluntarily said, oh yeah, this 14th Amendment is this great idea. It will help allow black folks to be citizens in this country. No, they fought it. They wanted to get their representation rights back in U.S. Congress. And because of that, they were required to do that. And once they did that, then they were given the rights to be back in Congress. So I think a history lesson, at least for our Attorney General, with understanding how we got to that point, that it wasn't only for African Americans, it was for all citizens, black and white, and any other race that was a citizen of this country, thereunto of the jurisdiction.
I appreciate your insight. It would be nice to get his insight too. I will be the moderator, but it would be a great discussion to have Alan Wilson here with you, being able to further go into detail on this, because I think this is something that is a big concern as to how we are interpreting what this law is and the Constitution. Colleague Rhodes, appreciate it as always. Thank you so much.